Now, on September 11, Kenya finally replaced its old version of the Companies Act, a thing that dates back to 1947, with an entirely new one. That, however, wasn't the only relevant bit of company law that came into force on that date. The Insolvency Act, which gives distressed companies the options to restructure as an alternative to immediate receivership or liquidation, also came into force, as did a new Special Economic Zones Act. That apparently is the first of its kind in Africa. Earlier on, I spoke to Mugambi Nandi, an advocate specializing in company and commercial law, to understand why the new Companies Act is so SME-friendly.
Small companies no longer need to have company secretaries, for instance. They no longer need to have an auditor unless they choose to do so, or if they pass the threshold required for having an auditor. And of course, the one-man company concept is pro-SME, because now you can be an entrepreneur on your own without having to invite other people to do business with you as a company.
Indeed. The law also does place a lot more responsibilities, I understand it, on company directors. Their fiduciary duties a lot more stringent in this particular law. Does that bode well for improving governance across the board, especially for listed companies in Kenya?
I think for listed companies, there isn't going to be much difference felt, because the capital markets law already requires quite some stringent governance practices. But for small companies, yes, there's going to be some challenges in terms of keeping up with the governance requirements under the Act. And I would say that what the new Act has done is given and taken at the same time, because if you look at the requirements, for instance, for directors' contracts to be approved by members, if you look at declarations of conflict of interest and in fact a requirement to avoid conflict of interest, you look at disqualification orders which can be made if the governance regime is not good in a company. Those seem rather stringent, but when on the other hand you look at the fact that a company now can have a director who's only 18 years old, can have only one director who's also possibly the sole shareholder, doesn't need a company secretary, doesn't need to audit its accounts, doesn't have to have physical meetings, can do meetings electronically. In a sense, those things make running the company easy, but at the same time they lower the threshold of the governance standards which one would expect.
Indeed. Let's get back to an earlier argument that you made with regard to auditing, especially for small companies. The Institute of Certified Public Accountants had complained about that certification, and the point they were making was that if you peg a company, a small company by definition, at something that has a turnover of less than 50 million shillings a year and net assets of less than 20 million, that's out of sync with the VAT Act, which essentially says that an SME by that definition is anything that has turnover of less than 5 million shillings on an annual basis. Do they have a point here?
Ram, I don't think they have a point. I am against professional associations trying to get business through legislation. If you look at who's interested in the audited accounts of a company, it will be the shareholders, it will be lenders, it will be government, that's for tax purposes, and possibly if the company wishes to issue public securities like bonds or things like that, then the general public might be interested in the financials of that company. So if those are the users of the audited account of a company, I don't see where the argument stands in regard to small companies, because the VAT regime has a totally different purpose from what the Companies Act is aiming at.